right, everybody. Welcome. Today, let me put these papers up behind me. How is everyone doing today? My name is Nate, lawyer and YouTuber, and we have finally an update from the court in the non sequitur case. What is going on, Aries? How's everybody doing? I'm giving a couple of minutes to get up in here because I know everybody's going to know what the update is, what's going on. So let me just stop a couple of these things. Christina, what's going on? Hey, if you guys like what I do, please don't forget to hit that subscribe button and what's it called? Super chats are welcome, but I understand people, it's a tough situation now. But yes, super chats are welcome. I was going to invite some people in here today, but it just is just been one of those days, one of those mornings you wake up and it's like, I got so much to do, especially a Monday. And is anybody else having this problem with Mondays too? Because like for Mondays for me, it's like I don't know what day it is. It's like I'll come in Monday, Tuesday. It's like what day is it? So I'm like, okay, today's Monday. It's like you lose track of the days now in quarantine. But you guys aren't here to listen to me go over what's going on in quarantine. You guys are here to see this. The court order, the thing that we've been waiting for. So let's get into it and let's move it. Oh yeah, I'm sorry. Let's put the lamp back in play. I forgot lamp is moving away. So here's the lamp. Uh-oh, come on, lamp. You're messing me up here. There we go. That is the lamp. Yes, the lamp is okay. The lamp is wearing a mask, it's social distancing, less than 6 feet. So doesn't want to get me sick. Okay. For those of you who've been under a rock or don't know what I'm talking about when it comes to the non-sex show. First, let me get this Christina Ray $4.99 super chat. Thank you. Get yourself some coffee. Should have got uncivil law. Yes. Thank you, Christina Ray. I love you. Should have gotten uncivil law, but this was kind of like last second and, with the kids and everything. So it just made it. Wow. Just squalled your notification. My husband. All right. So let's talk about where we're at and how we got here. Steve sued Kyle Curtis in court and Kyle just didn't respond. So whatever happened, Steve eventually got a default judgment. Now that default judgment is entered and Steve got a court order. That court order told Kyle to do certain things. Now, any attorney would tell you when you get a court order, you need to follow that court order, or there are situations, there are penalties, even imprisonment that could happen if you don't follow the court order. So Kyle seems to have tried to comply with the court order in one sense, but then in a second sense didn't comply with the court order, but filed his own motion, which was a motion to set aside the default judgment. So Kyle went back to court and say, hey, listen, I wasn't served properly, and now I'm asking the court to set aside all this stuff and to allow me to respond to the lawsuit from the beginning, right? To remove the default judgment that Steve legitimately got. So the next piece of it was Steve then responded with an order to show cause, saying that Kyle did not comply with the order. And since he didn't comply with the original order, he should be held in contempt. And Steve gave a couple of affidavits explaining why he believed Kyle didn't comply with the order. Now, Kyle didn't respond to Steve's motion. Steve responded to Kyle's motion, but Kyle didn't respond to Steve's motion. So the only thing the court had to go on with the order to show cause was Steve's affidavits. So now let's get into the court document, because now the court is now telling us what is actually happening and what it's going to do. So let me not, that's where we came from. So now let's go where we're going. So now here is the court order, and we're going to read it together to see what actually the court has come down with. This came out today. So this is the judge, Stephen McRae versus Kyle Curtis, the order on the motion to the order to show cause and the motion to set aside the default judgment. So the court says now pending before this court, this is just explaining to what the court is talking about, both the motion for the order to show cause by Steve and Kyle Curtis's revised motion to set aside the default judgment. So the court is saying we're going to talk about both of these things. So a hearing on each of these motions would be appropriate prior to ruling. However, absent mutual consent, no hearing can be held on or after June 1st, 2020, pursuant to the office. Now, obviously, we're going through the coronavirus pandemic. So they've held all court hearings off until after June. So unless both sides consented to their not needing a hearing, both of these issues, there need to be a hearing for both of these issues. So the court's saying that's what we're going, this is what we're going to do. So the court further finds that it should not issue a further ex parte relief beyond the partial default judgment it entered in this action. So in other words, the court is saying, okay, right now, before, ex parte means we've only been hearing from one side, essentially. We've only been hearing from Steve, and now we can't just give him anything else until we can have a hearing. So that's what the court is saying in this line. We're only hearing from one party, but it seems to be appropriate that we hear from both sides. And again, that can only happen after June 1st. So the court acknowledges a couple of things. It acknowledges Steve McCrae's report that Mr. Curtis has failed to comply with the judgment, and therefore requested an order to be issued to compel Mr. Curtis to appear and show cause why he should not be held in civil contempt pursuant to North Carolina. So, and that's essentially what I would ask for. And Steve's attorney is smart. He hasn't complied with the order. We have a court order. Court, you need to do something. So the court is saying, this is what we have. Now it says Mr. McCrae supplemented his request with a supplemental affidavit. That was the affidavit that we read last time on March 23rd, asserting that Mr. Curtis failed to abide by the court's instructions and judgment by not turning over the Twitter account, but instead deleting it, not turning over access to the non-sequitur Discord, which Mr. Curtis contends he does not administer, a contention which Mr. McCrae challenges in his affidavit, not turning over ownership of the YouTube channel, but instead that he intends to retain 50-50 ownership of the channel. Steve McCrae's compliance order, providing a list of inaccurate usernames and passwords to the accounts associated with non-sequitur, and failing to provide financial documents. So again, the court is only hearing from one side. This is saying we're only hearing from Steve. We're only hearing from Steve. He's saying all this, and we're only hearing from one side. We haven't heard from the other side. Let me check the chat to make sure we don't have any questions or anything. Any questions for me? Now, to be honest with you, it's going to be hard for me to catch questions because reading this, and so either tag me or throw me a super chat so I can see the question pop up and it'll be there, but I don't see anything as of now. So we're into it. The court is just going through some background. Let me continue with the motion. It says, now it's giving us the purpose of civil contempt. The purpose of civil contempt is to preserve the rights of private parties and to compel obedience to orders and decrees made for the benefit of such parties. So they're going through the legal mumble jumble of what it is and the standard. Now, the standard here to initiate civil contempt procedures is called probable cause. And it's the same thing like in a criminal context, but the court here lays it out. Probable cause refers to those facts and circumstances within the judicial official's knowledge and of which he has reasonably trustworthy information, which are sufficient to warrant a prudent man in believing that the allegation that the alleged contemptor is in civil contempt. So just need some facts or some information that will lead the judicial officer to believe that, hey, this is actually true. And it's the same in criminal proceedings. Number 7 says the proceedings for civil contempt may be commenced by order of the judicial officer, directing the alleged contemptor to appear at a specified reasonable time and show cause why he should not be held in civil contempt. So again, the court is going through what civil contempt is, what the standards are, and how we're going to get there. And it's going to explain that the next sentence, such an order may be issued on the affidavit of one with an interest in enforcing the order and finding by the presiding judicial officer that there is probable cause to believe that the alleged contemptor shall be held in contempt. Now, one thing that's interesting about this particularly is that the court has only had Steve's side in this particular motion. Kyle didn't respond. And one thing it also leads me to believe is that since Kyle didn't respond, the court only has one side to go on in the issue with the contempt issue. So it's saying that, hey, more or less, and again, this is just me reading the tea leaves. It's saying more or less that, Kyle, you gave me this motion to set aside the judgment, but now when Steve sends in all this other stuff about you not complying, you didn't reply to that. So it's not like the court doesn't know that he knows what's going on. It says, you know what's going on. You followed your motion too, and you haven't responded to that. So I have to make these rulings in law based on the information and the facts that I have that are now uncontested. So, Kyle has gone through this twice. He's done this twice. He's actually not responded to this motion, which is causing him in trouble. I think I have a question here. I'm sorry. It's hard for me to catch these questions. Nate Brody, without proper service, just jurisdiction. Yes. But the court's going to go into that. So the court's just kind of dispensing with this and explaining to you why it's coming, why it's ordering this hearing and how it's going to. So we'll get to the second part about the jurisdiction piece. But first, let's just get through this. So where we're at now, the court is just laying out the standards for the contempt order, the standards for having a hearing, and how it's coming to its order. It says, so again, it's issuing this order based on an affidavit of one of the parties, one of the interested parties, which is Steve. Once it is determined that probable cause exists, the burden shifts to the alleged contemptor. Now, this is where I think Kyle has the issue. Once it is determined that you have probable cause, which here you do, you have one person through affidavit, Steve saying through affidavit, he didn't comply with the court order. And here's the reasons why. I don't have Twitter. I don't have this. I don't have this. He should have given it to me. You ordered it in court. So there's probable cause based on his affidavit. The burden shifts to the contemptor, to now Kyle, to show, and it says it right here, exactly what Kyle needs to do. To show that he should not be held in contempt, that he lacks the means to comply, or that his non-compliance is not willful. And they give a citation for that. So here, the court even cites now, the court's only means of compliance of a person who is found in civil contempt is imprisonment as long as the civil contempt continues, subject to time limitations. So this is obvious that they're saying Kyle can go to jail. We can imprison him if he does not do this. So if he doesn't do this, he can be put in jail until he complies. So this is real. Kyle has not complied with the court order and can be put in jail if he does not comply. Let me go on. Here is, okay. Number 8, materials of the record are unrebutted affidavit testimony filed. The dates support the finding that there is probable cause that Mr. Curtis willfully violated the court's January 23rd judgment, and specifically that he failed to provide Mr. Recur with, then again, this is because he didn't respond to the order to show cause. It's unrebutted. So Kyle essentially made the same mistake again. He didn't show up to court. Then he shows up and says, hey, hold on, here's a mistake, take this away through this. We asked for the default judgment to be set aside. But then when Steve then responds with the order to show cause, he didn't respond to that. So the court is like, these allegations are, as it said, unrebutted, the unrebutted affidavit testimony. So that's what it's working with. And to be honest with you, the court gets it right here. If you don't respond and tell me that this is wrong in some way, then I have no choice. So now it tells you specifically, Mr. McCrae with the associated accounts has failed to relinquish control. This is Mr. McCrae has shown that he has failed to relinquish control of the associated YouTube channel and has not timely produced the requested financial documents. Again, if Kyle would have responded and said, hey, I had produced the financial documents, I had done this, then the court can do something. But since he didn't respond to that, then the court says, well, I can only do what Steve says, because Steve is the only person on the record saying that these things didn't happen. Number 9, Mr. Curtis has not responded to Mr. McCrae's last filing. Boom, there it is. And he has not and he is not required under the order of the Chief Justice. So that's the stay of that is the stay of execution. Because we're going through the pandemic, he didn't respond, but now he doesn't have to under the order kind of holding everything. But for those orders, the court would issue Mr. McRae's requested order that Mr. Curtis appear to show cause why he should not be held in civil contempt until he has fully complied with the court's judgment or demonstrated adequate grounds that such judgment must be set aside. So this is the crux of it. If Kyle can show adequate grounds that the judgment should be set aside, then Steve's judgment goes away. Then that judgment and all that requested document, that goes away. So Kyle has to do one of two things. But the court's requesting him. He's going to have to go to court, and he's going to have to prove either this default judgment needs to be set aside, or he is not willfully not comply with the court order. I'm going to stop here and go right back to the chat to see. I'm just looking to see if there's anything. Again, there's a lot going on in the chat. So, either, and here it only, one of the weird things about what's this thing called? StreamYards, is that it only highlights the super chat. So if people tag me, I can't even see it. I'd have to go to but let me try. I'm just trying to see if I can see him. It's like impossible. I think I see one. All right, I found something, but it's late though. So if anybody who's tagged me before, I'm sorry. I'm just, just is what it is. It's a little difficult. Nate Brody, can Kyle show that the business in his and doesn't need to do these things that Steve is asking for? Well, again, it's all going to be up to Kyle to show what's like. The court the court doesn't know what's really going on, right? It only can rely on the information that it's getting from the parties. And one party is saying this person more or less committed murder, and the other party is not saying anything. Then it's like, what do we have? This guy's telling me you committed murder and you're not saying anything. So I can only assume that you committed murder. Again, it actually doesn't work that way in a criminal context, but that's essentially what's going on here. In a criminal context, you actually have to prove that you have to prove your case. In a civil context, you don't have to prove it. You just have to allege it and then let it come back. Yes. All right. So now I'm getting people because I can see because I'm on this page, so I can see this. Nate, what grounds will Kyle have to argue to get the order set aside? He's had to prove that he didn't live there. He's got to prove that wherever they sent the documents, that he doesn't live at the place they sent the documents. That's what you have to show. I got a super chat from Angry Roach. Let me put that up. Angry Roach, thank you so much. $10 super chat. So the circus continues. Thank you, Angry Roach. Thank you. Yes, the circus is continuing. Thanks for your super chat, Angry Roach. Give me 1 second. Let me go back to the document. So I ended at Curtis has one of two things. He either demonstrates adequate grounds that he didn't comply with the judgment, or he has to demonstrate adequate grounds that the judgment must be set aside. One or two options. Now, the court goes on. It says, in light of the court's inability to proceed in this matter, by this order, the court advises Mr. Curtis that the court's order remains in full force. That makes sense because we haven't ruled on this to set aside the default judgment. So that order remains in full force and effect. And that while the court makes no final judgment of fact or conclusions of law prior to the hearing scheduled, so they scheduled a hearing, if Mr. Curtis, in fact, willfully violated and continues to violate the judgment during the period in which the court is unable to hold the required hearing before finding him in civil contempt, the court will give appropriate consideration to imposing all permissible sanctions, if necessary, requiring Mr. Curtis to be in prison until he fully complies. So that means they're saying if Kyle continues to do this stuff, delete stuff, then, hey, he may be imprisoned with a court order. Mr. McRae, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis. So they're threatening to put McRae in jail, it looks like, too. Mr. Gray in turn is advised that the court will respond appropriately if his assertions prove to be without basis. And I think that may be, remember when Steve went and Steve said, hey, there, Unirock put something on the, said he's going on the channel and doing this in the court. So they're saying there's even though Kyle, if you keep messing up and Steve keeps saying this stuff, we're going to put you in jail. But if Steve, we find out that your assertions are baseless, then you're in trouble. So this is starting to get very ticky-tacky. Let me go back to the chat. Okay. Thanks again for the super chat, Angry Roach. Let me just scroll up to see if I missed anything else. So there seems to be threats all around. Ah! Hello, Nate. Okay, so someone else is asking me a question. Again, if I'm missing your questions, I'm so sorry, but it's a little tough with this system. Hello, Nate. I've asked you a question in the comments of the Trump video about non-qualified Supreme Court justice. Well, again, if you're approved by the Senate, even if you're not qualified, I've just quickly read through it. It doesn't matter if you're, there's no requirement that you actually even be a attorney to even sit in the Supreme Court. As soon as if you're approved by the Senate, then you're good. So, that's the only check. So Steve has been, so it's made it very clear. Let me just make sure this is clear. Mr. McCray, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis. Warning to both. Kyle, don't do any more craziness. Comply with the order. Steve, you better be right, because if you're telling me BS, you're going to be in trouble. Interesting. The parties should govern themselves accordingly. And they dated it today. So, Judge James Gale. So, at the end of the day, what have we learned? Well, we learned two things. Number one, the court order, the default judgment order, is still in effect. And Kyle has been ordered to continue to comply with this order. That's number one. Number two, if Kyle does anything else that seems to be non-compliance with this court order, the court has threatened to put him in jail if he continues to not comply, deleting the Twitter account, that type of stuff. That would be a problem. Number three, I'm on three, I think. Number three, if McCray is giving out baseless allegations about what Kyle is doing, he will be in trouble. So no more of this bull crap. It's got to be real stuff, because if your allegations are found to be baseless, well, let me say it exactly how the court said it, because I know how sensitive this is. So the court is saying just about McCray. If Mr. McCray, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis. So again, it's warning McCray, you got to be careful too. You have to be careful. If you give us bullshit, then you're going to be in trouble also. And at the end of the day, there will be a court hearing on two things. Let me put myself back on screen. The court hearing is going to be after June 1st, and it's going to be on two things. First, whether Kyle was served properly, and if he was not served properly, the order goes away. The second is if Kyle wasn't served properly, then this order to show cause, all that stuff goes away. It's moot. It does not matter. If the court finds that Kyle was served properly, then they have to deal with the order to show cause and determine whether Kyle willfully didn't comply with the order. And if he did, he could be in prison until he complies. So that's where we're at. So what do you think? Do you think Kyle is going to jail? Do you think Steve is going to get in trouble? The court has kind of laid it down. No more bullshit. No more bullshit about he's running to stream with Unirock and there's no stream. It's like, come on. And I think that's kind of where this is going. You've turned in these affidavits saying these things are happening and they're not happening. So if you're telling me these things are happening and they're without basis, then you're going to be in trouble too, Steve. And it's telling Kyle, understand this. It's telling Kyle to understand this. The court order is still in effect. You have to comply. And if you continue to do things that seem to deleting a Twitter account, which is a mistake. I've always thought that was a mistake. I don't know if it's deleted or not, but that's a mistake. And if you continue to not comply or not even tell me what you're doing, then you may be put in jail before we can have the hearing. So right now you have this kind of basis where it's comply. So I don't know what's going to happen now. I would suggest Kyle needs to get an attorney, or at least send something to the court to let him know what his position is, because right now, based on the order to show cause, there's only the court's only hearing from one side, and that's the problem. All right, Heretic is asking, Nate Brody, could you please explain the order within the context of the process service and why it appears to have ignored it? Why has the judge not mentioned it? No, the judge did mention it. All right, this is so for Heretic. The judge did mention it. This order is about both. What this order is doing is two things. The motion to set aside the default judgment and the order to show cause, they're talking about them together. Now, what the judge is doing on one end is saying, we have an order, civil contempt. Yes, here's the procedure and here's what you need to prove. And that based on this, the order is still in effect. He has to comply. Kyle still has to comply. And if he does, any more spoilage or something like that, he could be put in jail. That's the first piece. The second piece is to rule on the order to set aside the default judgment. They have to have a hearing where Kyle then brings in the evidence to show A, B, C, and D, because both sides, if you remember earlier in the order, it said both sides didn't waive this request for a hearing. So there's going to have to be a hearing. The hearing can only be had after June 1st. And since it's just because that's just the way it is. Now, since Kyle has not said anything about the order to show cause, they're assuming that everything Steve is saying is right. So that's what's happening on that end. But the court at the end made it very clear that there are two things that are going to happen at that hearing. They have to determine if the order to set aside the default judgment, if that's legitimate. And if it is, then this order to show cause is BS. But if it's not, if Kyle cannot prove that his order that more or less he wasn't served properly, then the order to show cause has life, and they have to deal with that. So that's what this order is essentially saying, and it's warning them both to not do anything that's going to hurt the case anymore. It's warning both. It's warning both Steve, and it's warning both Kyle. So that's what we have here. So this is just what it is. I want to thank you guys for watching. And if you have any more questions in the chat, let me just run through it real quick. But and let me see. Here's one. Nate Brody can arrest Steve. Well, if he's making his criminal contempt in if he's doing it in North Carolina, he can. But again, I don't think Steve. Well, let me make it very clear too. Steve may. I don't think Steve may be going. The threat of jail isn't really for Steve. It's for Kyle. The threat of jail, of being in prison, is for Kyle. Kyle has a real threat of being imprisoned here. I think Steve, the court has, and I don't want to call it a threat, but it has warned Steve. And it's warned Steve that don't bring us bull, and that's what this is. This is saying don't bring us bull, because if you bring us bull, then you're going to be in trouble. And that's essentially what this is. Mr. McCray, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis. So it's also letting him know that don't bring us the BS, because if you bring us the BS, you may be in trouble. Nate, it says. Oh, you gotta hit me with something better than just the Nate. It's hard to see these things. This is Nate. Are you a licensed attorney? I am a licensed attorney. I am not licensed in North Carolina. I am not at all licensed in North Carolina. So this is not legal advice for anybody who lives in North Carolina. I'm just reading the order just like anyone else and giving my opinion on it. So understand that. So from what I'm reading, it seems like the court is trying to just deal with this, and it seems like the court just wants everything to kind of just settle down too, because again, it's now you're waiting for what is it, April, May, June? You're talking about 2 months where they can actually do anything and they're going to bring everybody in. So it kind of just wants, I think, wants everything to calm down and doesn't want, Kyle to then destroy everything and then has to go. Yeah. So it's just saying, hey, now, Kyle has his court order. And if you have a court order, you got to turn over the stuff. Now, he should turn it over. And if he has, he's got to tell the court, hey, I have, I turned over the financial documents. I have done this. I have done that. He needs to say it because the court is saying, well, you haven't said it. So I only have one side of the story. Just like before, I got to believe that one side until you tell me something different. And he hasn't told him anything different. So if anybody has any more questions, I've been checking it out. Nothing more. Listen, thanks again for watching. We have now, everybody knows June 1st is the date. The court is saying, nothing else. It's warned both parties to act accordingly. And we're going to see what happens in 2 months when the Chief Justice order is appropriate. And the court at that time is going to handle both the order to show cause and the motion to set aside the default judgment. I'm hoping right now, I just don't know how everything is going to work out. Especially, I don't know how the set aside the default judgment is going to work out because, that process down there, sometimes you just don't know. But I do think that Kyle's, this whole case for Kyle is hinging on that. Kyle's case is hinging on the default judgment being thrown out. If it's not thrown out, I think Kyle's got a real problem. But so is Steve's case, because if that judgment is thrown out, then all that stuff that Steve gave over, he's more likely going to have to give that back because the default judgment would be not, it would be moot at that point in time. So, but we'll keep up as always. So listen, guys, thanks again for joining me. My name is Nate. If you're new here, don't forget, hit the subscribe button down to the channel down below. Thanks for those who gave me the super chats. I really, really appreciate it. And again, try to stay safe, especially in this time. You know what I mean? Stay safe and understand that this is it is what it is. I know there are a lot of people scared on all this stuff, but just stay focused. We'll all get through this together. And if anything, what state do you gotta watch my stuff more, man. This is gotta watch your stuff more. I am, I'm going to let you watch some more videos to see what state I'm licensed in. But again, this is my YouTube name. This name right here, here. This right here. This is my YouTube name. That's not my my actual name. So, but again, I'm not giving legal advice, especially in North Carolina, because I don't know how anything goes down there. So it just is what it is. So if anything, my name is Nate, lawyer, YouTuber, and as always, I'm going to check you guys later. Good luck and peace.